Hello guys, welcome to this video. Today we are going to examine the sources of international law. Sources of international law refers to resources with which international law is crafted. So Article 38(1) of the statute of the International Court of Justice outlines 5 sources of international law, namely international conventions, international customs, general principles of law recognized by civilized states, judicial decisions, and finally the teaching of publicists. Let's examine each of these in turn. So number 1, we start with international custom. So over time in any human society, certain ways of doing things and pattern of conduct become desirable and become what we call the norm. So over time these acts predominate and people do them subconsciously or unconsciously. It is just in the doing. So these practices or acts most of the time do not have a legal expression, but they are people do it. We can see people do them day by day. So this is what we call a custom. Definitely a custom is a general practice that is accepted as law. For an international custom to be valid, it has to show some degree of unanimity or maybe some degree of agreement between the countries that are practicing that custom for it to be valid under international law. So for example, there is a case involving Anglo-Norwegian fisheries, whereby the United Kingdom tried to invoke its own way of measuring the breadth of the territorial sea, but the International Court of Justice objected it, saying it cannot be a common custom to bind the Norway too. So this is one example. So a custom has to be shared by the countries concerned for it to acquire what we call international legitimacy. The second source of international law is what we call international conventions. International conventions refers to formal consent to commonly binding terms. So most of the times this consent is expressed in the form of signatures and ratifications, maybe upon documents. Those documents are what we call treaties. Treaties, in other words, we are talking about agreements between countries that have some form of legal expression. There is a very important principle in treaties. This principle is called Pact Sunta Servanda. What it basically means is that once a state decides to maybe gets into a contract, it has to keep its part of the deal so that the treaty is not violated. So an example of a treaty is the Vienna Convention on Diplomatic Relations of 1961. We now turn to the third source of international law. The third source of international law is what we call common principles of law in civilized states. Most scholars refer to this, maybe they really say that it has a great relationship with the principles of natural justice, which in other words is maybe the use of reasoning or reason faculty. So the use of reason faculty makes human beings act in similar ways sometimes. So the principles that maybe are very, very important include fairness, justice, and equity. So most of these principles are adopted from principles of natural justice. So I'll give you one case law. In the Chozou factory case of 1928, pitting Upper Silesia versus Poland, the International Court of Justice affirmed that it is a general conception of law that every violation of an engagement involves an obligation to make reparation. The fourth source of international law is what we call judicial decisions. So judges in the process of interpreting the law may sometimes create it. So judicial decisions bears a very close resemblance in what in municipal law is called the principle of judicial precedent. What this means simply is that some decisions that were made in the past, when confronted with a similar case, they may be reincorporated to help solve these cases. Thus, it is now the principle of judicial decisions. So, an example of this is the Alabama claims arbitration case. The final source of international law is what we call publicists, or the teaching of publicists. So publicists are writers, most highly qualified writers. So some philosophers, maybe people of great academic distinction, may sometimes make writings on different aspects of international law, and this maybe a judge may do his research and find the writings and use them in that judgment, in a way creating international law. I'll give you an example of a great writer who has done this, Grotius, who is also known as the father of the law of the sea, advocated for the freedom of the sea, and that the sea is an international territory whereby each state owns it. So due to this, each state also has the freedom to exploit it equally. So this scholar really influenced the development of what we call UNICLOS, or the United Nations Law of the Sea. So this is an example of a scholar contributing greatly to the formation of international law. Thank you for watching this video. Like, share, subscribe, and hit the notification bell.